Here's the issue. If you have a checking account or a credit card or a private student loan or any number of financial products, there's a good chance that you have given up your right to go to court if that financial firm cheats you. I'll tell you one thing. When it comes to what's right for consumers, I listen to service members, veterans, seniors, consumers, small businesses. I don't listen to bank lobbyists. When a bunch of bank lobbyists tell you that they know what's best for consumers, hang on to your wallet. Millions of Americans of all political parties think the game in Washington is rigged against them. And this vote is Exhibit A.
Welcome back to Outside Counsel. I'm your host, Jeffrey B. Simon. This is an episode on how forced arbitration is destroying consumer protection. Every passionate plaintiff's lawyer laments the fact that the enforcement of arbitration clauses insidiously embedded in consumer purchase and employment contracts is empowering a corporate repeal of your Seventh Amendment rights, the right to trial by jury. Some, like me, participate in organized resistance against this destructive trend. Arbitration is not new to America. However, the way it has been prolifically weaponized to strip consumers and workers of rights and remedies is a more modern device. Arbitration was initially devised as an alternative method to resolve business disagreements. Merchants in commercial transactions could agree by contract to resolve any future contractual disputes that may arise between them by referring the matter for determination by a third party, an arbitration panel, rather than have those matters decided by a jury. Today, however, many of America's largest companies force consumers or employees who levy complaints to privately arbitrate those grievances in secret. And they do so to ensure that no jury can ever decide them. Arbitration clauses in consumer purchase and employment transactions are primarily designed to deprive Americans of their Seventh Amendment rights and to discourage them from bringing claims, irrespective of the number of people claiming harm or the merits of their contentions. As two judges observed in a recent law review paper, a person cannot open a bank account, buy a car, use a cell phone without contracting away the Seventh Amendment right to a jury trial. Companies like Walmart, Walgreens, Home Depot, Lowe's, and Best Buy, among other conglomerates, are aggressive users of forced arbitration language for online transactions, whereby consumers waive the right to trial by jury for any disputes with the companies, including any conflict arising from the purchase of any product or service. Anytime someone in America rents a car or opens a bank account or purchases a child car seat, they sign away the right to trial by jury and agree to forced arbitration. In 2018, there were at least 826,537,000 consumer arbitration agreements in force in America. In that year, 81 of the Fortune 100 largest companies in America routinely incorporated compulsory arbitration provisions somewhere in the small print of their purchase or service agreements or in the product package labeling or warranty language. A few years ago, several customers complained to homeware e-retailer Wayfair that they received products infested with bedbugs. One Illinois-based purchaser, Ronald Gorney, claimed that only after he installed a headboard that he bought from Wayfair did he notice several small insects crawling around the upholstery. Gorney's bedbug experience occurred 2 years after a Brooklyn woman received an official apology back in September of 2016 from Wayfair's CEO, Niraj Shah. Wayfair sent her the letter after she complained that the company delivered a bedbug-infested headboard to her home. In other words, Gorney lodged a particular customer concern with which the company was already quite familiar. After Gorney complained to Wayfair, the company successfully compelled the matter to binding arbitration. The court agreed with Wayfair that Gorney was required to arbitrate his claim because sandwiched among 5,000 finely printed words in Wayfair's customer agreement, there was language requiring that any dispute between the customer and Wayfair was to be resolved by binding arbitration, thereby ensuring the process remained private, actually secret, and effectively unappealable. Today, virtually every American consumer has knowingly agreed to arbitration provisions that will bind them if a manufacturer's product causes them harm. Moreover, if you purchase a defective consumer product or a company otherwise mistreats you as a customer, you can also be bound by arbitration provisions that do not appear in the purchase or service agreement itself. Sometimes the insidious waiver is in the product labeling or package insert. Nonetheless, in those cases, courts routinely hold that the consumers may only arbitrate their complaints with the seller. Similarly, in most instances, workers can no longer hold dishonest or abusive employers accountable in a court of law for wrongfully firing them, cheating them out of compensation, or for most other forms of job-related mistreatment. Consumer Reports conducted surveys that confirmed that an overwhelming majority of consumers and job applicants don't notice arbitration agreements in the purchase, service, lease, or employment agreements they sign. And if they do, they don't understand they are waiving a constitutional right. Think about it. Isn't a 230-year-old bedrock of individual freedom a lot to give up in exchange for the use of a credit card or a cell phone? Especially when it can take an hour or more to read all the small print terms of credit card or cell phone contracts. Consider with me a hypothetical. What if you're a gun owner who supports the Second Amendment right to bear arms? How would you react to learning, only after you signed a car lease or an apartment lease, that you unknowingly but permanently forfeited your right to possess a gun in that car or that apartment? How would you feel if a month or so after you signed both a home rental agreement and a car lease, the police, without probable cause or warrant, show up at your home to search your car and every room in your house? You, of course, refuse to consent to the search. If one loses the right to trial by jury, one has little or no power to enforce their other rights when they are violated. And to add insult to injury, the terms of forced arbitration language levied upon consumers and employees are typically a one-way proposition in favor of the company. You waive your right to trial by jury if you have a claim, but if the company has one against you, it doesn't. It can haul your ass right into court. Consumers and workers fare poorly against big businesses in arbitration, and that's why America's largest companies utilize forced arbitration language so pervasively. The American Association of Justice, sometimes called AAJ, is a group of trial lawyers staunchly opposed to forced arbitration. In 2019, AAJ conducted a study. The study revealed that from 2013 through 2018, there were approximately 30,000 consumer arbitrations conducted by the two largest arbitration service providers. Let's do a little math now. That's about 6,000 arbitrations per year. Of those 30,000 arbitrations, only 1,909 consumers won anything, which is an average of 380 consumer winners per year for each of 5 years. Thus, in only 6.3% of cases arbitrated by the two leading arbitration providers in America did the arbitrators award money to a consumer. In over 93% of the cases, the arbitrators stuffed the consumer, awarding them nothing. In many of those cases, the consumer lost money because he or she had to share the cost of arbitration with the defendant company, a process that can be quite expensive. Among America's largest and most powerful corporations, telecommunications giant AT&T is one of the most aggressive users of forced arbitration against its consumers. Over the same period of 5 years through the year 2018, AT&T appears to have used forced arbitration against its customers more than any other American company. The complaints against the company covered a wide gamut, including allegations of overcharging, fraud, and bait-and-switch promotions. Not only does AT&T typically include arbitration language in its service agreements with consumers, it also aggressively uses arbitration clauses to prevent the formation of consumer class actions. AT&T's consumer service agreements typically state, "Please read this agreement carefully. It requires us to resolve disputes through arbitration on an individual basis rather than jury trials or class actions." A consumer class action is a tool permitted by our federal court system, as well as the laws of many states, whereby consumers with a common grievance against a company or a group of companies can file a lawsuit together for the purpose of obtaining a remedy for harm that was caused to each of them. And these class actions are an essential tool for obtaining a remedy when each of many American consumers, whether it be thousands or perhaps even millions of them, believe they have been mistreated or cheated by a company in the same way, but the monetary value of each individual claim is too small to justify pursuing on an individual basis. Imagine, what if a large cellular service provider sells 2 million people a phone repair warranty for $25 a piece, but then doesn't honor it when it becomes clear that there is a common manufacturing defect in the phone that it sold to those same 2 million people? In that circumstance, consumers who bought the defective phone and bad warranty will rightly want to complain that they've been mistreated and deserve remedy. But pursuing a lawsuit for the cost of the $25 warranty and perhaps the money needed to fix or replace the phone does not provide enough financial potential recovery itself to persuade a skilled lawyer to take the case. That's because the cost of preparing, filing, and prosecuting the case against a big company like AT&T, armed with many lawyers, would greatly exceed the individual consumer's claim for damages. But that's a $50 million windfall for the cellular service provider for the warranties it sold but refused to honor, apart from the revenues it also reaped from the sales of 2 million defective phones. Ask yourself how aggressively you alone would be willing to pursue a claim against a powerful corporation that snookered you out of $25, as opposed to if you understood you'd be participating in a claim along with hundreds of thousands or even millions of Americans who were similarly cheated by the same company. Strength in numbers increases the likelihood that an effort to hold a company accountable for deceiving customers will be pursued. In a consumer class action, where all the claims for damages are pooled into one demand for repayment against the company, capable plaintiffs' lawyers might accept that case. In that scenario, the cost of working up one liability case against the company that is common to all the consumers who bought the defective phones and bad warranties may be much less than the total financial losses the consumers collectively claim. In society, we want consumer class actions to be available in circumstances like the one described above. Otherwise, companies with large volumes of customers would be free to beat or cheat consumers collectively out of a ton of money, but do it through individual transactions that by themselves are economically too small to justify formal legal action by the individual consumer. AT&T has lots of lawyers, and they know all of this. Arbitration has itself become big business. Arbitrators can make substantial livings doing nothing but being repeat arbitrators. When an arbitrator makes their living by being chosen on a repetitive basis to perform that task, that regularity raises questions of financial bias in favor of the repeat corporate players. The terms of arbitration often permit the parties to pick their favorite arbitrators to decide a dispute. Arbitrators are sometimes lawyers who spent considerable parts of their legal careers defending similar types of cases on behalf of similar types of companies as the defendant in the matter they are being paid to decide opposite you. Ask yourself, why would a big company that frequently forces complainants into arbitration pick an arbitrator who has a track record of deciding cases in favor of consumers against big companies? You're right, they don't. Unless you are a lawyer or live with a lawyer who has lots of time, patience, and free legal advice to provide, you're not likely to carefully review the terms of use in sales agreements when you buy everyday goods and services, whether big or small. Even if you did, what is the likelihood that you would have the time and the wherewithal to contest these terms and force a corporate giant to revise them for you? It's therefore easy to foresee that the systematic unfairness that can emerge and swell if big companies with sophisticated legal teams are free to slip fully enforceable arbitration clauses, no matter how one-sided, into purchase agreements or employee handbooks that can require an hour to comprehensively read, as well as perhaps years of legal training to fully understand. This imbalance widens when these contracts are for basic goods and services that almost everyone needs, such as household appliances, cell phones, and jobs to pay our bills. In 2010, in the case of Rent-A-Center versus Jackson, the Supreme Court increased the power of arbitrators once more. Jackson was fired by his employer, Rent-A-Center. According to case records, he had spoken out numerous times about being passed up for a promotion he felt he deserved, considering his service record with the company. He finally received his promotion, but was fired only 2 months later. He sued his employer, alleging racial discrimination and retaliation. Rent-A-Center moved to compel arbitration based upon broad language in the employment agreement that required arbitration for all past and present disputes arising out of Jackson's employment. Those documents also included a clause that an arbitrator, rather than any court or agency, shall have the exclusive authority to resolve any question of the enforceability of the arbitration language. In other words, an arbitrator, rather than a judge, will decide whether the arbitration provisions will apply to the dispute, and if they do, they get paid. Right? It's the fox watching the hen house. If the arbitrator decides arbitration doesn't apply, they won't get paid to conduct one. The arbitration provisions also require Jackson to pay half the costs of the arbitration. He argued that the arbitration provisions were unconscionable and should be invalidated. The Supreme Court ruled against Jackson and did so while splicing and dicing its reasoning like a Ginsu knife to produce a particular result. The court determined that Jackson's unconscionability arguments were directed at the arbitration agreement itself, but not specifically at the provision of whether an arbitrator versus a trial court judge or agency should decide the threshold question of whether there should be an arbitration at all. Based on that selective analysis, the court ruled that the delegation provision, that is, who decides whether there will be an arbitration, must be treated as valid. And any challenge to the validity of that agreement overall had to be left to the arbitrator. It's unclear how the arbitrator then ruled because arbitrations are private, which in turn prevents the establishment of instructive precedent for the public to know and to consider. Legal observers complained. This effectively gives the arbitrator discretion to decide whether or not he or she has the authority to perform a task that he or she will receive income for completing. thus creating an inherent and untenable conflict of interest. Any company that has a lawyer and a lot of customers who wants to prevent customers from aggregating claims against them, no matter how egregiously they may mistreat those customers, can simply include in their purchase agreements or lease agreements or employment agreements class action waiver and compulsory arbitration. And the United States Supreme Court says those are enforceable. That's the American way. And the current state of our law, where courts consistently rule that forced arbitration clauses, no matter how deceptive or punitive, eclipse the United States Constitution, combined with the secrecy of arbitration proceedings and how poorly consumers and employees fare in the arbitration process at large, has resulted in a destructive transformation of the civil justice system that harms the American public. When powerful corporations harm consumers or employees, they are less accountable for misconduct than ever before. You waive a constitutional right in almost every consumer transaction you engage in, especially the ones you conduct online. And according to the United States Supreme Court, that's fine. These iniquities multiply and sadly confirm the prescience and wisdom of Samuel Gompers, founder of the American Federation of Labor, who long ago, literally in the 19th century, observed, open quote, "Do I believe in arbitration? I do, but not in arbitration between the lion and the lamb, in which the lamb is in the morning found inside the lion. When a man puts a pistol to my head and tells me to deliver, there is no arbitration. There can be arbitration only between equals." Consumers are now proverbial lambs consumed by powerful predatory corporate lions. This supplication was foreseeable and avoidable for a long time, yet we allowed it to happen. I know what you're thinking. Damn, Jeffrey, you got any good news for me? Yes, I do. There are things we can do that will make a profound difference and reverse this unjust trend. Number one, you should just look for arbitration clauses in the contracts you sign. Consider marking out the language and placing your initials next to the changes you made to the contract. If the vendor won't do business with you for insisting that if they mistreat you, you still preserve your right to use the court system, perhaps you should do business with a competitive vendor more willing to stand by their work and the promises they make. Number two, contact your home state's 2 senators. Peacefully but firmly express to them and their offices your disdain for compulsory arbitration and insist that they take legislative action to prohibit its continued use. There is a bill in Congress called the FAIR Act, which stands for Force Arbitration Injustice Repeal Act. That bill passed the House in March of 2022, although it died in the Senate. It would likely pass the House again, even that divided House. That bill would prohibit compulsory arbitration in several types of legal disputes, including employment disputes, consumer disputes, antitrust disputes, civil rights disputes. But that law needs traction in the Senate. And if you make clear to your 2 senators how important this is to you, and you encourage others to do the same, perhaps it will create movement. Because I can share with you that that kind of political, collective action has made a profound difference at least once before in eradicating the pervasive evil of compulsory arbitration. It did so in ending the use of compulsory arbitration in cases involving sexual assault and sexual harassment. In 2021, both chambers of Congress passed the Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act of 2021 and President Joe Biden signed it into law.
Between half and three-quarters of all women report that they have faced some form of sexual harassment in the workplace. And too often, they're denied a voice and a fair chance to do anything about it. Today, we send a clear and strong message that we stand with you for safety, dignity, and for justice. Forced arbitration shielded perpetrators, silenced survivors, enabled employers to sweep episodes of sexual assault and harassment under the rug, and it kept survivors from knowing if others have experienced the same thing in the same workplace at the hands of the same person. And yes, there will be cases where victims want their claims resolved in private, but some survivors will want their day in court, and that should be their choice and nobody else's choice.
Now, when a person is accused of sexual misconduct in the workplace, they can't use an employment contract to compel the accuser into arbitration and to keep secrecy around the nature of their actions. That is exactly the kind of transparency we need in relation to all civil disputes. If parties want to arbitrate, fine. But if one of them is hoodwinked into arbitration, that is not fine, and it should be illegal and therefore unenforceable. And we can do this, but only if we take action together. On the next episode of Outside Counsel, I'm speaking to Robert Skeeter Saline, a nationally renowned litigator who took on Blue Cross Blue Shield after they denied coverage for his life-saving cancer treatment. Tune in for incredible insight into a major victory for Americans against the insidious claim denials perpetrated by healthcare providers en masse. You will not want to miss this incredible story. This podcast is produced by Shannon McNeese of Revel and McVeigh and Larry Shavana. The opinions expressed on Outside Counsel are neither legal nor medical advice. The views and opinions expressed in this podcast are those of the speakers, guests, experts, and/or host. They do not expressly nor necessarily reflect the opinion of any institution with which I am or ever have been a member and should never be attributed as such. Thank you for tuning in to another episode of Outside Counsel. I'm Jeffrey B. Simon.